2.10, the court in action. So while we have sort of this like evolving court, there's been a lot more continuity than change. So Chief Justice Roger Taney ended up replacing John Marshall, and the court's like operation changed a little bit. Like there was an increase to 9 judges, and this court was very determined to protect slavery as a state's right. And in Dred Scott v. Sandford, this isn't like a required case, but it's mentioned and gives context. Dred Scott had traveled with his master into free territory and claimed that by having lived there, he should have his freedom. However, the court ruled that he wasn't even a citizen and therefore had no legal right to be a party in federal court. And then they went even further and said that the slave's owner had this constitutional right to property. Now, corporations and states. So the court examines business, trade, workplace, especially as the Industrial Revolution was happening. Congress and stuff was trying to address how it was very unfair at that time, but also those more involved with business, they really liked the laissez-faire aspect, or very minimal government approach is another way to put that. That's what they wanted. And the court had to go between is this permitted by the Constitution, and can the state or federal government therefore make a law on it? They also began to overturn various state, health, safety, and civil rights laws, and therefore ended up shaping social policy. For example, they threw out a congressional act and ruled income tax statute as void. However, that doesn't necessarily stand today. Anyway, they developed to have this more conservative reputation, and during the progressive era, the court made some more exceptions, but were very quick to lean more into that strict constructionist view of business regulation. Strict constructionist means you're going based off the direct word of the Constitution, line by line, the very literal meaning of it, versus a liberal constructionist is leaning into a society lives and changes, then therefore the Constitution has to change with it to adapt and have that same sort of meaning, in a state of now versus then, I guess. They ruled that Congress can't use commerce power to suppress child labor, and they became even more conservative when former President Taft ended up becoming Chief Justice. So now the New Deal and Roosevelt. During the Depression, the court transformed. Charles Evan Hughes replaced Taft, and this was a very mixed group with 4 strong conservatives. They struck down business regulations, ruled against minimum wage. Roosevelt actually proposed to add 1 justice for every justice over the age of 70, claiming that it would relieve overload, but it was really more just because he wanted to dilute that power of the 4 strong conservatives. There was a change ideologically when in West Coast Hotel v. Parrish, a state minimum wage law was kept, and Justice Owen Roberts became the switch that saved 9. Which meant that Roosevelt didn't feel the need to pack the court with more justices. Anyway, Roosevelt pressed with more legislation and was able to appoint 9 new justices as he continued to be reelected during his time. So next, a court dedicated to individual liberties. So we're talking about the post-World War II court, which was protecting and extending individual liberties. Before this, there were kind of mixed messages. For example, they upheld the internment camps for Japanese Americans. But after all of that stuff, they remained fairly consistent in protecting individual liberties and rights and stuff. So the Warren Court extended many liberties under Earl Warren. They oversaw the internment of Japanese Americans. They did not please traditionalists because they overturned state policies that were created by democratically elected legislatures. And this unpopularity ended up resulting in this questioning of legitimacy, although they hadn't done any impeachable acts. And there was this civil rights versus liberties. They took on a lot of those cases. For example, and there's a little graph on page 197, this table right here. Brown v. Board of Education, separate but equal, that idea in segregation of schools, that violated the 14th Amendment and its Equal Protection Clause. Mapp v. Ohio ruled that evidence illegally obtained was therefore inadmissible in court. Engel v. Vitale, which ruled that public school-sponsored prayer was unconstitutional. Gideon v. Wainwright was that all citizens need a lawyer, even if they can't pay for one. Miranda v. Arizona is that those arrested have to be informed of their rights. That's where you get your Miranda rights. So, you have the right to remain silent. Anything you say or can will be used against you. Anyway, Tinker v. Des Moines, Independent Community School District, that was that students can participate in non-disruptive symbolic speech in schools. And we will get into more of those much later. Then we have the Burger Court. So Nixon ended up replacing Warren with Warren Burger. So after Earl Warren, you have Warren Burger. This is the court that ruled on Roe v. Wade, so they outlawed and modified several state anti-abortion laws so that all women could have abortion through the first trimester. Their court often struggled to get a majority, so many cases went undecided and they got more and just became overworked and tired. Then you have the Rehnquist Court. So Reagan put William Rehnquist on the court. The Senate was not very easily confirming this. Or rather, the Senate took a while to confirm this. And they accused him of racism. And he had various, differing views, and so he became known as, the Lone Ranger when he was on the court. And he was very in favor of upholding states' rights to place limitations on things. So, legislating after unfavorable decisions. Not all decisions are final. The 11th Amendment, which further defines a court's jurisdiction, was made in response to Chisholm v. Georgia. So, anti-federalists warned that new federal courts could overpower state courts, and they saw it as, an encroachment on liberty. So, South Carolina residents sued because they wanted war debts from Georgia's government. Supreme Court ruled that the federal courts had jurisdiction over this, and then the proposed 11th Amendment prohibited the federal courts from considering certain lawsuits against states and excuses state courts from hearing some suits against the state if based on federal law. And this is the only amendment to alter the judicial branch's jurisdiction. And that one's a little confusing, but it's not bolded. So my guess is that you're not going to need to know anything more other than it deals with the judicial branch's jurisdiction over cases. However, that's just for if you're taking any in-class quizzes or anything, because obviously I have not taken the AP test yet. There have been some other amendments that have been ratified as reactions to Supreme Court's decisions. For example, the 14th Amendment overturned the Dred Scott decision by guaranteeing citizenship to those born in the United States, so we talked about that case in the very beginning of the video. Congress passed a national tax on individual income. Court struck down the law, we talked about that as well, but then the 16th Amendment followed and allowed federal income tax. So basically, amending the Constitution is the surest way to get around a court's decision, but obviously it's very difficult. And in recent years, there have been movements to stop abortions, prevent same-sex marriage, criminalize flag burning, and all of these failed. But a more practical path is to pass laws in slightly different forms. Now, implementation. So the court decides the principles, and they will order the citizens or government to take or refrain from action. The executive branch must then enforce this. And basically, courts can only order things from the courtroom. Putting it into effect is another matter entirely, requiring those other governing authorities, like the executive branch, to carry out the decisions that the court has made. So for example, this could mean that Congress has to rewrite or pass new laws in this area if the court rules on that. And the implementing branch doesn't always cooperate. And so this is considered when the Supreme Court makes a decision, and they'll kind of assess the potential cooperation. So how do cases reach the Supreme Court? So the Supreme Court has 48 formal rules and also a bunch of less formal traditions that kind of guide their operation, but they also have this original and appellate jurisdiction. Appellate? I don't know. And they rarely actually have original jurisdiction, and this happens for interstate disputes, in which they are acting as a trial court. They just take most of their cases from the 50 states and 13 U.S. circuit courts, mostly through the federal system because the circuit courts are more direct. So first, a petitioner files a petition for certiorari, which is this argument of why the lower court made a mistake. This is reviewed to see if it's appeal worthy. If yes, it's added to this discuss list. They can't consider hypothetical or theoretical damages. The claimant must show actual damages, and there is this rule of 4 to take on the case, so 4 justices have to agree to accept the case. And finally, opinions in case law. The most senior justice in the majority writes the opinions or assigns another justice to write it. And the majority opinion reflects the ruling, and usually the writers have a certain expertise or are very passionate about the issue if they're writing the majority opinion. There's a thing called a concurring opinion, which is you agree with the outcome, but not necessarily with the reasoning of the outcome. So yes, I agree that we ended up here, but you took this path and I took this path. And finally, there's the dissenting opinion, which is a disagree. It does not take the force of law, but it explains and sends a message to the community about that justice's thoughts and stuff. And I lied, that wasn't finally, because finally there's the per curiam opinion, which is this decision issued without an explanation. Thank you, I hope this helped.